All right, everybody, it's another Fishing with Viva back on the pond. There are no alligators in this pond. I have scoped it out thoroughly before we get into the latest Fani Willis update. What am I fishing with tonight? I just bought a Rapala topwater, sort of like a Zara spook type thing, but the walk the dog thing. This was $17.99 American. I don't know how expensive lures have gotten, but flabbergasted. Anyhow, we'll see if we catch anything. So the latest in the Fani Willis, Sato, the attorney for Trump, has filed the motion before the Georgia Court of Appeals to hear the appeal. Bear in mind, Scott McAfee issued the certificate of immediate review to the effect that, yes, this is sufficiently important that it needs to go up to the Court of Appeal, and so he allows it to go to the Georgia Court of Appeal. But bear in mind, the Georgia Court of Appeal needs to agree to hear it and then issue the correct ruling. The Georgia Court of Appeal could say, we're not hearing it. From what Phil Holloway has explained to me, the Georgia attorney, who's also got a new Rumble channel, Inside the Law with Phil Holloway, it only takes one judge of the panel of three to say we're going to hear it. So we're all cautiously optimistic that the court system is not so thoroughly corrupt up in Fulton County, Georgia, or in Georgia at large, that the Court of Appeal is going to unanimously say we're not hearing this. It takes one of the three to say yes, we're hearing it, and then I presume it's majority decision if they overturn Scott McAfee's decision. Listening to Sato's argument, it's a beautiful 50 some odd page motion. It really feels like it was scripted based on my assessment after the hearing and after Judge McAfee's incomprehensible, illogical ruling. But like I said in my assessment, it's nothing of a big lawyer brain that I have. Anybody who saw that would have come to the same conclusions in assessing Scott McAfee's irrational, incoherent decision. Basically, Sato, for and on behalf of Trump, says Scott McAfee's decision doesn't make sense within the four corners of the decision. Scott McAfee said that there doesn't need to be an actual conflict, and he didn't find one, but it could suffice that there is an appearance of conflict, and he did find one. He just didn't have the judicial cojones to say yes, and the remedy for that odor of mendacity is disqualifying both of the participants in that mendaciousness and not just one of them. So basically, Sato argued the judge's decision doesn't make sense on its own. They do argue, however, that the judge is wrong, in fact, that there is, in fact, an actual conflict in that Fani Willis had a financial interest in prosecuting this case. She had a financial interest in the case, and as a matter of fact, it was a little bit more than the $12,000 that the judge found in the ruling. That is closer to $17,000. But they argue a two-prong approach. Judge McAfee got it wrong as a matter of fact, and he got it wrong as a matter of law, which is exactly what I said after the hearing. The judge laid out matters of fact that will allow any court of appeal with half a conscience to come to the opposite conclusion of law. But he basically said, as far as a matter of fact goes, there is in fact an appearance, despite what Judge McAfee found. That Fani Willis knew darn well she had to report the income or the gifts that she was getting from Nathan Wade, who was specifically listed on her financial disclosures. And when she said, nope, I haven't gotten any gifts more than $100, when Nathan Wade was listed on these disclosures, that is the clear financial benefit. Couple that with also totally untruthful testimony, that there's an actual conflict there. The judge, they argue that the judge got it wrong as his assessment of testimony. That the judge says, yeah, there was no real details, confirmation as to the date this relationship got started, and then discredits Yurdi's testimony, even though Yurdi, as a matter of fact, the woman who rented out her condo to Fani Willis, where she and Nathan Wade were bumping uglies and knocking boots, doing the judicial nasty. It's like there was no reason to disregard Yurdi's testimony, and in fact, it was corroborated by other people's testimony. So as a matter of fact, the judge got it wrong. There was an actual conflict of interest. But then as a matter of law, the judge got it wrong that there was an appearance of conflict, and you don't resolve that appearance by only getting rid of one of the two parties. They go through the entire factual briefing of the case, the gifts, the fact that the judge said, it was legally improper for Fani to make those extrajudicial statements at the church. The fact that, there was no bookkeeping, that the explanation that they repaid in cash, that she repaid Nathan Wade in cash, was not, totally unbelievable on its face, but it's improper. It's suspicious. It's a little curious that anyone would be walking around with tens of thousands of dollars in cash, allegedly reimbursing what they knew would have been improper gifts and benefits, and there's no way to prove it above and beyond saying, yep, I did it with cash, there's no evidence, no paper trail, and that's it, you have to accept my story. So they brief the entire factual history again, but they do go into arguing the law on that famous Williams case. You'll recall that Scott McAfee said, look, I don't know what to do. There's no precedent for this, which might be an indication as to how out of this world and unprecedented this is. Yeah, there might be no precedent in this, not because it's such a thorny legal question, but because it's such an absurd factual pattern that this has never happened before, because people have half a good sense to never let this happen. So there's only one case that they're relying on, Williams, which apparently, according to Scott McAfee, did not provide the requisite direction, allowing for a lower court to disqualify Fani Willis. Open a parentheses. Some people were arguing that Scott McAfee had his hands tied to some extent, because if he comes to the conclusion that we've all come to because we all saw the evidence and listened to what happened, that Fani Willis is in fact a perjurer like Nathan Wade proved himself to be. Nathan Wade lied in interrogatories, concealed assets from his wife that he was divorcing. If we came to the conclusion that Fani Willis perjured herself, lied under oath, which we all know that she did, well, if he disqualifies her for that, and on that basis, what of then all of her other prosecutions? She's the DA of Georgia. People have been convicted under a woman who has proven herself to be corrupt, totally irresponsible, but also, if Scott McAfee were to come to that conclusion, perjure herself. What about all those other convictions? You could imagine that a number of the people that had been convicted by her, especially the ones who had been convicted based on cell data, might say, yeah, we kind of want to look over our cases again if we were convicted by a corrupt, perjury-prone, judicially improper prosecutor. I'd like to look at this case. And somebody would say, you couldn't do that without opening up a huge can of worms, yada, yada, yada. To which I might respond, if people were convicted, even if guilty, but wrongly convicted by a corrupt DA, open up those cases. That's justice. And in fact, Scott McAfee, above and beyond being a judicial coward in this case, might be a judicial coward in that he might be denying justice to other people who might have been wrongfully convicted by a corrupt, perjury-prone, lying scumbag of a DA. So bottom line, the judge came to the conclusion that Nathan Wade was untruthful and that he needed to be removed from the file. Came to the conclusion that Fani Willis's conduct, both in the courtroom and outside of the courtroom, was unbecoming of the profession, that she behaved improperly when testifying. She had to be reprimanded, by the way. I hope everybody remembers that. She behaved improperly while testifying. Her decision-making proved to be problematic time and time again. Her out-of-court statements, which Sadow made a lot of good points about, the forensic misconduct, her out-of-court statements, according to the judge, legally improper, and yet there was no legal remedy, legal sanction for them. The judge said, oh, if she does it again, it might be time for the defendants to make a motion for a gag order, yada, yada, yada. And then what does Fani Willis do in her first public statement since that hearing? Goes out and plays the race card again, goes out and paints herself as a role model for black women, the face of the feminist movement. I don't know why this is getting tangled so much. After being reprimanded by the court in that decision, what does Fani Willis do? She goes out and opens her big yap again and does the exact same thing.
I don't feel like my reputation needs to be reclaimed. Let's say it for the record. I'm not embarrassed by anything I've done. I guess my greatest crime is I had a relationship with a man, but that's not something that I find embarrassing in any way. And I know that I have not done anything that's illegal. And so I don't feel like my reputation needs to be reclaimed. And when I tell you the outpouring of women, and I'll tell you this, especially African-American women who will just say, we are so proud, you are such a good representative of us. But I would be lying to say it's only African American women. I have had Caucasian women, Asian women, Indian women. I told Jeff one day, I didn't think I was the face of the feminist movement, but somehow I became it. And I think that women feel like women are treated differently when they're professionals, and they're proud to see someone that is strong and trying to do the right job. Certainly flawed, like every human being is flawed. My father has a saying, only one perfect man walked the face of the earth, and they crucified him. I am not a perfect human being, but what I am is a hard-working human being, and a human being that loves the community I serve, and who understands this seat does not belong to me. It belongs to the people, and as long as I'm here, I'm going to try to do the job in a way that's honorable.
So not only did she not learn her lesson, it almost seems like she's been empowered by the fact that Scott McAfee didn't yeet her from the file, and Sadow makes these arguments in the motion to the Court of Appeal that the legally improper out-of-court statements that made statements to the effect of the guilt of the defendants prejudiced a jury pool. The speech in front of the church, by the way, wasn't just in front of the church. It was a nationally televised speech. And so those legally improper statements qualify as forensic misconduct and warrant disqualification. And the principle in Williams, that case that they're citing, in fact provide for it. So it's an extremely compelling brief. I mean, it's a motion. It's extremely compelling because it's legally and factually correct. The bottom line is we've entered such a realm of political prejudice that people now just are willing to forego the judicial process entirely to get the convictions that they want against the people that they hate because of their political prejudice. Somebody was tweeting yesterday, Eddie Smith, a guy named Eddie Smith. You can go check out the tweet. I'm going to show a flash of it now. Eddie Smith tweets out a statement from Trump. He says, we have to go back to being a nation of law and order, a system of law and order. To which Eddie Smith replies, mother effer, you're out on bail. And I'm like, you know who else was out on bail because of trumped up bogus charges in a wildly prejudiced society? Martin Luther King Jr. Ironically enough, the letter from Birmingham that he wrote, I believe it was on Easter Friday, which we just had yesterday. Martin Luther King, 1957, pulled over for going 30 in the 25 zone because of racial prejudice. That, in retrospect, is an obvious injustice. And yet somehow people are blind to their political prejudice. Oh, well, Martin Luther King getting pulled over for going 30 in a 25. That's raging racial prejudice, total injustice. Donald Trump getting fined $500 million for an alleged fraud where there's no victim, no complainant, and no fraud. Well, that's fine. He shouldn't have broken the law. He should have just done business a little more carefully. Martin Luther King should have just driven his car a little more slowly. People are so blinded by their prejudice, they don't understand that they're violating their own principles of justice because they think the ends justify the means and they've got to get their political opponents. It's a fight for survival. It's a fight for political survival. And the people who once pretended to have principles, the people who are administering justice, are in fact administering injustice and violating their own sacred principles of equality and justice for all. With that said, this lure is not working tonight. I'm going to switch it up, but now you know the latest in the Fani Willis stuff. I don't know how long the Georgia Court of Appeal has to agree to take it up. I think it's got to be done relatively quickly. We'll know if they agree to take it up, and we will be following it to see if they render the correct decision. The one Scott McAfee ought to have rendered. I'll say the only thing in Scott McAfee's credit, but it goes both ways because it is a double-edged sword. He laid out the factual pattern for the Court of Appeal to come to a different conclusion in law, which they will have a lot of deference to do. Talked about it before, but the Court of Appeal typically has more deference to override a lower court decision as relates to matters of law. Less so when it comes to matters of fact, like assessing credibility of witnesses, because that is something that the lower court is in a privileged position to assess. But matters of law, they can overturn the decision if they simply disagree with the conclusion of law, and Judge Scott McAfee issued a number of findings of fact that would allow any Court of Appeal to come to a different, and I would say correct, conclusion of law. And Sadow, because they're not going to miss the argument, says also the judge came to wrong assessments of fact, and that there was, in fact, an appearance, sorry, not an appearance, but an actual conflict in this case. So we'll see what happens. Doesn't look like I'm catching anything tonight, but my goodness, is it a beautiful evening. All right, one last cast, and if I don't catch anything on this cast, I'm going to switch the lure, but the video's going to end now. If you like what I do, you know what to do. Like, share, subscribe. Viva Frei on Rumble. Viva Frei on Twitter. We've got an amazing locals community. vivabarneslaw.locals.com. It is alligator mating season, by the way. We went to a place called Loxahatchee Wildlife Refuge today, and we saw gators. And when I say that you can see gators if you're looking around and paying attention, you could see the gators, especially 12-foot gators, man. Oh, and they were mating. It was beautiful. All right, that's it. We're done. Oh, peace out, peeps. Booyah! Hold on a second. Okay, it's going all the way down to the bottom.
Oh, Daddy, there's a fish over there.
Where?
Right there.
How big?
He's moving.